Chapter 8 will cover the Texas Judiciary. The learning objectives for Chapter 8 include: describe the structure of the Texas court system and its position within the constitutional framework of federalism. Describe the roles of the participants in the Texas court system and the procedures used in trial and appellate courts. Trace the growth of minority and women judges in the Texas judiciary. Characterize the judicial controversies in Texas and their impact on public perception of the courts. Describe the legal and constitutional rights of suspects, the classes of crimes and punishments in the Texas Penal Code, and the administration of criminal justice in Texas, and illustrate the increased policy role of the state courts with examples. We have to remember, as part of the federal system, the Texas courts have a relationship with the national court system too. Texans fall under the jurisdiction of state and federal courts, meaning that depending on the crime you commit, you could end up in the state court system, which we're going to talk about today, or the federal court system, which you'll learn more about in your federal government class. The Texas courts have taken the lead in protecting many civil and political liberties, like Smith versus Allwright in 1944, where the Supreme Court of the United States ended white primaries. Now, as far as the state and federal courts, I said there's two courts. You can go through two court systems. Most people are tried or fall in the state court system. More than 95% of all court cases are considered state court cases. There are also two types of cases that are heard in the court system, both state and federal, but we're talking about state right now. There are criminal cases that are part of what's called the Penal Code. They're criminal cases. It defines most criminal activities and their punishments, things that are against the law. So if there's a law against for murder, stealing, those things, if you do that, you are going to be in the criminal or the penal, have that status within the court system. Felonies are the most serious criminal offenses. Misdemeanors are more minor ones. But the courts also hear civil cases or civil lawsuits. Generally, in these cases, there are no crimes that have been committed. Generally, it's involves a conflict or a dispute between two or more people or two or more parties, can include businesses or organizations that have a dispute. And an example of a civil case would be a divorce or child custody case or a lawsuit against somebody, maybe a broken contract, where really no law has been broken, but only one party feels like it has been wronged by the other party. And usually there's just money involved in these transactions, or custody, things like that. Also, different courts, and there's many different courts, and we're going to talk about each of the different courts, have what's called different jurisdiction, meaning what type of power or right do they have to hear a certain case. So the jurisdiction of a court is the official power to make legal decisions or judgments. And certain courts have jurisdiction over certain types of areas and cases and geographic areas. First, let's talk about a couple of the two main definitions of jurisdiction that I want you to know. First is original jurisdiction. This is the first court to hear a case. So say if you're charged with a crime and you show up for your trial, where you have the jury, you have the judge, and you have the prosecutor and your defense attorney, this is the original jurisdiction court. It's where all of the evidence and is presented to the jury. It is where you ask witnesses questions, and you can profess your innocence. So, and it's where also they determine guilt or innocence. So the original jurisdiction court. After that, if you feel like that your court case in the original jurisdiction court was unfair or violated your constitutional rights, you may appeal to what's called the appellate courts, which have appellate jurisdiction. They review decisions made by the lower courts. Now, they don't have a new trial. No new evidence is put forth. They just look at the process. They look at everything that the judge did, the prosecutor does, and the defense attorney does, and they determine whether it was a fair trial or not, or if there were any problems. They may reverse the decision, overturn a conviction. They may order a new trial. They may also say there's nothing wrong with it and let the original decision stand. Now, another part of the structure of the Texas court system is the highest level of court, which is where your highest level appeal goes, like your last chance to have a decision overturned or to win a case. Of course, in the U.S., it's the U.S. Supreme Court, but in Texas, there are two separate highest level courts, and that's why it's called a bifurcated court system. The first is the Texas Supreme Court, which hears all civil cases, and generally the Texas Supreme Court oversees the whole Texas state court system. But as far as cases that they hear, it's just civil cases and also juvenile cases. Now, the Texas Court of Criminal Appeals is the other highest court that hears all criminal cases. And so that's kind of your last chance in the state of Texas to win an appeal, is if you were committed a felony or a misdemeanor, would be to win in the Texas Court of Criminal Appeals. Also in Texas, there are 5 levels of courts before you get to those highest courts, the Supreme Court and Court of Criminal Appeals, which is included in the 5. First, you have the municipal and justice of the peace. These are the lowest level local courts. We'll talk a little bit more about them in a little bit, but no serious crimes are generally heard in these courts. Then you have the county level courts, which hear somewhat more serious types of crimes and different types of crimes. Then you have the district courts, which hear the most severe types of cases, all the way up to and including murder and things like that. Then you have the Court of Appeals, which we talked about a while ago, which is the courts that hear appeals from the district courts. And then the Supreme Court and Court of Criminal Appeals. So that's the hierarchy, from lowest to highest. County level courts, you have the constitutional county courts, which is the county judge, who presides over the county commissioner's court. Initially, under the Constitution, they were also judges. This judge is elected countywide and is head of the policy-making body for the county, which is the county commissioner's court. They have original jurisdiction in small fine misdemeanors. Now, in most counties, the county judge is not an actual judge. It's just like I said, oversees the city council. In most larger counties, you have what's called county courts at law, which are replace the county judge in the job of being a judge. Relieve workload of constitutional county courts. Some specialize in probate, like probating wills and things like that. Judges elected are countywide and must be lawyers to be a county court at law judge. And their jurisdiction in civil disputes varies depending on how much value is the lawsuit worth. I mean, how much people are being sued for, or what's the amount of money that is will be determined in the civil dispute. The district courts, they hear original jurisdiction cases. They hear civil cases with $200 or more in damages. Of course, some of the original jurisdiction of the districts and the county courts they overlap. District courts can also hear divorces, election disputes, and slander charges, title disputes, official misconduct of public officials, and then of course felony cases. All levels of felony cases can be heard, will be heard in the district courts. To serve as a district judge in a district court, you must be elected. You must be at least 25 years old and must have practiced law or served as a judge of another court for 4 years prior to taking office. When you are elected to a 4-year term. And in Texas right now, there are 456 total district courts that serve to prosecute or try crimes or civil cases. The Court of Appeals, which is the Intermediate Court of Appeals, they hear appeals from the district courts. There are 14 of those that hear the appeals from all those district courts that are in Texas. They hear criminal and civil cases on appeal from the district courts and county level courts. They're required to have one Chief Justice and 2 other justices, so at minimum 3. But legislature can add more, change it. But as of now, each Court of Appeals has 3 justices. They are elected to 6-year terms and must be at least 35 years old with at least 10 years experience practicing law. Once again, they are elected. Heavy loads somewhat are offset by the Texas Supreme Court dispersing cases to all appellate courts. So if you have one appellate court that is just having too much workload, the Supreme Court can share that workload, the jurisdiction of that appellate court, and give it to one of the other 13 appellate courts. This is just a map of the geographic areas that each of the different Texas Court of Appeals covers. Of course, Houston has 2 because of its large population. But as you can see, where it's less populated, the one Court of Appeals would cover a larger geographic area. Like out in West Texas, the El Paso Court of Appeals covers a huge amount of area because that's not a very populated part of the state. Now let's talk about the Supreme Court and the Court of Criminal Appeals. They're the 2 highest appellate courts, the courts of last resort, as they call them, for appeals. So if you lose in district court, you can appeal to the appellate level, the appeals courts. And if you lose there, your one last chance potentially is to have the Texas Supreme Court, if it's a civil case, or the Texas Court of Criminal Appeals, if it's a criminal case, hear your case to try to possibly overturn your conviction. The Texas Supreme Court decides civil appeals and sets up rules and procedures for the rest of the courts, the rest of the courts in the state of Texas. It appoints the Board of Law Examiners, which review judicial conduct, specifically of judges, and they also can have disciplinary authority over state judges who break the rules or do not adequately carry out their jobs. And they also hear juvenile appeals of all juvenile cases. Of course, the Texas Court of Criminal Appeals, all they hear are criminal appeals. That is it. They're elected to for both of these, they're elected to a 6-year staggered term and must be at least 35 years old and have 10 years of legal experience. As far as the Texas judges, the high court judges and the intermediate court or appellate judges usually served on lower courts prior to those winning those elections to serve on the higher courts. Lower court judges usually come from private law practice, although they may also come from the prosecutor's office or the district attorney's office, where they served as a prosecutor, not necessarily private law. 2/3 of state level judges currently are Republicans because of course they run in partisan elections for these judge seats. In 2013, Republicans held all 9 seats in the Texas Supreme Court. Most Texas judges are white males. There are, gradually getting more diversity within the judicial population, but still it's not, the number of white male judges is not representative of the general population. All county level judges and higher level judges are elected. Basically everything over the municipal level are elected in partisan elections in the state of Texas. Who are some other participants in the judicial process besides the judges? Well, you have the prosecuting attorneys and the clerks. So you have county attorneys, which represent the county in court. You have the, as the prosecutor, you have the district attorneys who represent the state or the county in the court. Once again, as the prosecutor, they're the ones that are trying to convict somebody, uh, as opposed to the defense attorney who's trying to prevent a conviction for a crime. Then you have the county and district clerks. They handle the records. They make sure everything is done above board and all the paperwork is completed properly and all the T's are crossed and the I's are dotted. Also, each court has a bailiff that helps to maintain order in the court, kind of the security officer, police officer of the court. Law enforcement officers' investigations, of course the police, play critical roles in arrest, detention, and investigation of persons accused of crimes. So generally, there's a fairly close relationship between the law enforcement officers, the police, sheriff, and the district attorneys or the county attorneys, because they're both playing a role in trying to investigate and convict accused criminals. Of course, our courts, as we should have learned a long time ago, and of course, as we see on TV, use a jury system. Many of you that are doing this may have served on a jury in the past, and if not, you likely will in the future. But there's a jury system. There's two types of jury. First is the grand jury. The grand jury is a 12-member jury that is selected by a district judge, and they typically handle felony cases. Basically, their job is not to determine guilt or innocence. Their job is to determine if sufficient evidence exists to proceed with prosecution, to actually charge the person with the crime. So the prosecutor would take evidence to the grand jury and tell them, okay, this is what we have. Is there enough evidence? And of course, the prosecutor is going to try to persuade them that there is. Is there enough evidence to actually charge this person with a crime? They hear only evidence provided by that prosecutor. They don't hear the defendant's side of it at this point. If 9 of the 12 jurors agree, then an indictment or a true bill will be issued. There is concern about bias in the grand jury because they are appointed by the judge and may have, potentially biases with regard to not just prosecution, but there's oftentimes can be ethnic, racial, gender bias within these grand jury systems because they are just populated. The grand jury has members of the community in it. The other type of jury is the Petit jury. These juries are the kinds you see maybe on the television that you might be called for jury duty to serve on. They're composed of 12 members in the district courts and 6 members in county courts. The attorneys screen potential jurors. So you got the prosecutor and the defense attorney. They get to screen the jurors, ask them questions and whatnot to find out if they're fair or unbiased, or if they have biases and wouldn't be appropriate jurors. There's 2 types of challenges to remove a potential juror. One's a peremptory challenge, which basically is you can remove somebody for any reason you like. And the other is a challenge for cause, meaning that in the process of asking them questions, they've showed clear bias or the unwillingness to consider either the prosecutors or the defense attorney's point of view. Oftentimes in maybe capital murder cases where there's a potential for a death penalty, the lawyers, prosecutor, and the attorneys will ask the potential jurors whether they support the death penalty or not, things like that. The jury system in the Petit jury returns verdicts, which basically they determine the guilt or innocence. Criminal cases require a unanimous decision and proof beyond a reasonable doubt. Of course, proof beyond a reasonable doubt, that's kind of a gray area there. I mean, what's reasonable to some people may not be reasonable to others, but it's a pretty high standard for conviction, beyond a reasonable doubt. Civil cases require agreement of 10 of the 12 jurors in district court and 5 of 6 in a county court. So you don't need a unanimous decision in a civil case, but you need a unanimous decision of the court in a criminal case. Judicial proceedings and decision making. The trial courts, like I said, a 6 or 12 person jury. Attorneys are allowed peremptory challenges. Unanimous jury verdicts required. Appellate courts, and I just restated those to compare it to appellate courts. Appellate courts, where the appeals take place, no jury. A panel of justices decides the case, is not a jury, and they simply review lower court proceedings. There are no lawyers. There are no, and because there's no jury, there's no peremptory challenges, um, and they just read the legal briefs of the previous case and hear and review the oral arguments of the previous case, and it just requires two of the three members of the appellate court to make a decision.